Alrighty, and sharing my screen. Okay, so welcome everybody. Thank you all so much for joining us on today's Lunch and Learn. This is our first kickoff Introduction to Sign Regulations community meeting. I'm Casey Judge. I'm with the Department of Planning and Development, specifically in the Zoning Administration Division. And I'm also joined by Mike Adams today here with the Department of Code Compliance. So we're really excited to have you all here today. I will note that this, as I mentioned, this presentation is being recorded. So a copy of that recording will be added to our Signs Part 2 website, as well as a copy of the PowerPoint slides. So you don't need to take lots of notes or detailed notes on the hyperlinks. They'll all be added to our website. So today we're going to cover a couple of different topics. So we're going to break it down into 3 sections. The first, I'm going to discuss an overview of the zoning regulations. Then Mike's going to take the lead on the zoning ordinance enforcement of those regulations and the signs in the right-of-way. And then I'm going to finish up with the upcoming zoning ordinance amendment that we have on deck. So we're going to go ahead and pause in between each of these sections and take questions and discussion on those sections before we move on. In order to participate, you have a couple of different options. You can enter a comment into the chat. Make sure that chat is going to everyone or all of the panelists so we can all see that comment. And then we'll go ahead when it's time to talk about questions and comments. We'll read that, that comment out or that question out and respond to it. You can also do a raise hand function. So if you open the participants tab, there is a hand icon in the bottom right-hand corner. So you can raise your hand and we'll basically call on you, we'll unmute you and let you ask your question or have your comment heard. If you're unable to find that hand button, but you want to be unmuted, please feel free to just add that into the chat that you'd like to raise your hand and like to have a question asked. And if you're calling on the phone, the *3 is the way to raise and lower your hand. So I'm joined by Carmen Bishop and Janan Cato today. They're both in zoning and they're going to be monitoring the chat and monitoring the hands and just trying to make sure we cover all of the questions. If we run out of time, we'll see. I'll have some email addresses at the end that you can feel free to send your questions or comments to. So with that, let's get started with the first part of the zoning ordinance regulations. So as many of you may be aware, the regulations that pertain to signs are included in Article 7 of the new zoning ordinance. These regulations recently underwent a rewrite in 2019 based on a Supreme Court decision, Reed versus Gilbert. Essentially, we looked at the regulations. We had to make all of them content neutral, meaning we could not regulate the sign based on the message of the sign itself. So in general, for permits, unless specifically exempted, all signs are required to obtain a permit. Notably, we do not require minor signs to obtain a permit. So those are your signs that are easily movable. They're typically not permanently attached to something. They include your A-frame or sidewalk signs, banners, posters, window signs, and yard signs, and then other movable signs. So we do have a list of other types of signs that do not require a permit, and that's going to be located in Article 7. We do get questions on minor signs for properties that are for sale, rent, or lease. So I did want to give a little bit of an overview on those regulations. We do limit those properties to 1 building mounted or freestanding sign. If they're on a corner lot, they can have up to 2 signs. And then the size of that sign and the height is limited based on the development type. So that ranges from 6 square feet and 6 feet high for single family developments, all the way up to 32 square feet and 8 feet high for non-residential developments or certain residential developments that meet that criteria. In terms of properties that are under active construction or alteration, for new non-residential development or for residential development that has a minimum of 3 dwelling units, we would allow one sign up to 60 square feet and 10 feet tall. If there is multiple road frontages, we do allow 1 additional sign, 32 square feet in size and 8 feet tall. These signs do have a 5-foot setback requirement, and they have a time limitation, as in they must be removed within 14 days of completion of that work. They cannot be displayed no matter what for more than 2 years from the date of the first building permit issued, unless they have requested and obtained a sign permit for that additional display time. For another type of development for properties that are actively undergoing construction or alteration, if it's an individual single family dwelling unit, it is limited to one sign up to 4 square feet in size and 4 feet tall. The sign is not permitted to be displayed before commencement of the improvement or the renovation work. So different examples of commencement include the clearing, grading, or excavation of the site, active demolition, whether the structure is being demolished are exterior or our internal features, delivery or staging of materials or equipment. So that could be a dumpster being delivered to the site or cabinetry being stored inside for a pending interior renovation, and any other similar activity that is beginning the work on the property. In addition to, just like the last allowances, there is a time limitation for these types of signs. They must be removed within 7 days of the completion of that work or within 6 months of the beginning of that work, whichever is less. Yard signs are another common type of minor sign that we have questions about. They are permitted on any lot developed with a residential use. We do have a cumulative size allowance of 12 square feet with no individual sign exceeding 4 square feet in size and 4 feet tall. We don't have a time limit or an overall number. And just as a reminder, like that previous Supreme Court case I mentioned, Reed versus Gilbert, we cannot restrict or limit the signage based on the message, based on the content. So it does allow for any sort of message on the sign that meets those limitations. For non-residential properties, in terms of the minor sign permissions, we would allow building mounted and freestanding minor signs. If you're located on a major thoroughfare, that would allow up to 32 square feet in size. All other lots are limited to 24 square feet in size. And we would permit just a maximum of 2 freestanding signs at 4 feet tall. So there's a link here if there's questions on if a property is on a major thoroughfare or not. That link does give those guidelines. And just really quickly, window signs, we do have limitations on them to a maximum of 30% coverage of the window on which they're located. A-frame signs or sidewalk signs, we only permit one sign 16 square feet in size and 4 feet tall. It does have to be set back and located within 25 feet of the entrance to the building or the site, and it also can impede any vehicular or pedestrian traffic. Really briefly on electronic display signs, we do allow the electronic messaging on a freestanding sign. One electronic display sign is allowed per lot, and it is limited, the display area itself is limited to 50% of the maximum allowed freestanding sign size of sign area. This message cannot move or change more than once every 8 seconds. There are limitations in terms of what color the background can be. And then there is a photocell requirement to control the brightness that has the automatic dimming at sunset. We do have a slew of special approvals, and I like this. That's kind of one of my foreshadowing slides of what we do want to look at with the upcoming zoning ordinance amendment. You don't really hear a lot about the special permits, but you'll probably commonly hear about special exceptions and comprehensive sign plans to allow for increased or additional signage with the public hearing and that legislative approval. So those processes are something that we do want to take a look at with the upcoming zoning ordinance amendment. And really briefly, we do have a lot of questions and complaints come in on prohibited signs. Did want to note that moving or wind blown signs are prohibited. So that's your wacky, wavy, inflatable people and your blow up signs. Those are prohibited in the zoning ordinance. And we do have a list of other prohibitions based on location or material listed in subsection 7:100.5. And this is more of an FYI for other notable sign regulations that are located in Article 7, like how the sign measurement is in subsection 7:100.7, and then the sign regulations by district are located in section 7:101. So these are good if you're, want to bookmark those sections. They're really great for different sign ordinance questions. And then these links are also really helpful. The top link is a link that explains the sign ordinance regulations. We have a page specifically dedicated to questions on sign permits and the process in order to apply for and obtain a sign permit. as well as a great FAQs page that answers a lot of common questions that we get in the county on signs. So now before we go over into Mike, we're going to pause really quickly and see if there are any questions on the current zoning ordinance regulations related to signs. Carmen or Jan, do we have any questions yet?
No, no questions have come up.
Okay, any hands raised?
Nope.
All right. Well, if you think of anything, feel free to drop it in the chat in the meantime, and then we'll go ahead and Mike, if you'd like to take the lead on the zoning ordinance enforcement process.
All right, thanks, Casey. Yeah, so everybody wonders what happens when there is a complaint that a sign on a property does not comply with zoning ordinance regulations. If a complaint is made to the county's Department of Code Compliance, known as DCC, an investigator will be assigned the case and will go out and inspect the property. So this slide, these are some details about DCC. Most of our enforcement programs are complaint driven and are mainly focused on the county zoning ordinance and the state's building code regarding building construction and maintenance codes. Okay. So DCC responds to approximately 7,500 complaints in 2020. A citizen can file a complaint by either calling our main number at 703-324-1314 to register a complaint, or they can visit our website at www.fairfaxcounty.gov/code, and they can register a complaint that way. And there's web forms for the citizens to fill out. And it's always important that we ask people to include a contact phone number so that way we can get back to them, update them. So these are our enforcement steps with an emphasis on enforcing the zoning regulations for signs on private property. These steps include conducting a site visit and trying to contact the responsible party, identifying the type of sign, determining if a sign permit is required, or whether the sign type in question is a type that is a flat out prohibited on the property. If there's a violation of the zoning ordinance sign regulations, a notice of violation, often called an NOV, is issued directing the responsible party to come to compliance within a specified time frame. When voluntary compliance is not achieved, litigation may be required to bring the property in compliance. Litigation may entail fines and/or a court order to require the responsible party to comply. And DCC will forward these cases to the Office of the County Attorney for action. They're the ones that represent us. If there is not a violation, the case is closed. In all situations, DCC staff reports back to the complainant about the findings of their investigation, if the complainant leaves that information. That's why it's always nice to be able to have that contact information so we can update the citizen of the reason why it is not a violation. So that way, they're not constantly putting in the same complaint over and over and wondering why the issue isn't being resolved. So contact information is very important, so that way we can educate everybody. Okay. So this is another program and another way that we regulate signs in the county, and it is not in the zoning ordinance. It is not based on complaints. It is through the county's illegal sign removal program, and it applies to signs that are placed illegally in the Virginia Department of Transportation's right-of-ways, which are commonly known as ROWs. Virtually all signage that is placed in the right-of-ways by an entity other than VDOT or its contractors is illegal and can be removed through this illegal sign removal program. If the signage is within the right-of-way, that is part of the program. Fairfax County obtained the state's approval to have this program on March 11, 2013, and the program officially started on July 1st of 2013. It's important to note that their program currently has 99 roads in it, so not every road that is owned by VDOT, the right-of-ways, are in this program. And the selected right-of-ways in this program are major roads, tend to not be in subdivisions, and the number of signs removed was over 15,000 in 2018 and over 9,000 in 2020. And in 2021, we removed about over 8,000 signs. So while DCC administers the program, all legal signage itself is removed by the Sheriff's Department Community Labor Force, which is also known as CLF. So once again, DCC, we do not actually physically remove any signs. It's with the Community Labor Force, which are monitored by the Sheriff's Office. Okay. Regarding how this program works, rather than operating on a complaint basis, the Community Labor Force drive the roads in the program on a routine schedule, picking up illegal signage in the right-of-ways Tuesday, Wednesday, and Thursday. Then DCC staff provides support to the program by routinely driving these roads and other programs Tuesday through Thursday, photographing and identifying all legal signage. DCC staff members also provide administrative support to the program by issuing informational letters, which are also known as warning letters, to first-time offenders, notifying them about the program and what possibly could happen if they continue placing signs in the right-of-way. If the responsible party continues placing signs in any of the applicable roads, then they are subject to fines of $100 per sign, and a $10 administrative fee. Like I said, we document all the signs on 9 roads, and sometimes if the people do not comply by this, they could accrue a very significant amount of fines. As mentioned above, a limited number of roads are included in this program, and virtually no neighborhood streets are included. However, citizens and civic groups who would like to remove signs from the neighborhood streets or other roads not included in the program are encouraged to seek permission on the VDOT's Adopt a Highway program. Okay. Are there any questions about the DCC's enforcement of the signs on private property, or questions about the illegal sign removal program from certain right-of-ways?
Yes, Mike, we do have a couple questions. So the first question, and I think actually both of these applied to the zoning ordinance enforcement, not the right-of-way part, but so the first question was, are sign complaints with DCC exempt from FOIA?
No, they're just like any regular complaints. So any FOIA request that we get, we forward that to our FOIA coordinator, who then will request any information about the case file.
So I might just follow up on the question a little bit. So I know that sometimes people, they want to submit a complaint anonymously, and I have heard that that's not as helpful for the DCC staff. And I'm wondering if you maybe could speak to that just a minute about, the difference between, submitting a complaint anonymously and how somebody could go about that versus the advantages of not being anonymous.
Okay. Basically, it's the same. If you'd like to submit a complaint and leave your information, which, like I said, we recommend so that we can contact you, is exactly the same way you'd like to do one if you're anonymous. Like I said, you can call over the phone, say, hey, I'd like to submit a complaint for this sign that I see on this private property. I think it's in violation of zoning ordinance regulations. We'll take all the information, where it's located, what type of sign, and what the sign says, so we kind of know what we're kind of looking for. But we will not put any of the information for the contact person as part of the complaint. But like I said, your complaint will still be worked. There'll be a sign created and addressed. The only difference is you will not be updated on the resolution of that complaint that you filed. Okay.
Are there any other questions in the chat or hands that are raised?
Yeah, we had another question asking where the time frame to comply are found or listed.
The time frame to comply, depending on the type of sign, usually we like verbally, it's like if you can remove it now, we go to a business, we see the sign, we go in there, we'll educate them. It's like, hey, the sign is not allowed. Sometimes some people, because they didn't know, they'll remove it immediately, so they'll comply then. If we do have to send a notice of violation, usually we tell them you have 24 hours to comply. However, with any notice that is being sent out, there's an appeal time frame. So normally we, will follow up after that appeal right time frame, because we want to make sure that we give every citizen their due process.
So we have one more sign. Not one more sign. Goodness, we probably have a lot more signs, but we have one more question. And this one is, who do we report illegal signs on utility poles on residential streets to?
That, if you could file that, it's definitely not DCC. If it's on like the right of way, you could contact VDOT for that issue, because normally all these utility easements are put in the right of way. So you would contact them regarding that type of issue. Or like I said, if you'd like to adopt that portion of roadway, you can contact VDOT and get into their adopt a right of way program where you could legally remove the signs. But DCC, from the zoning ordinance, we don't have any enforcement on those signs that are put in the right of way. And as I mentioned before, the signs on the right of way program does not work on a complaint basis, and it has to be on one of the roads that are actually in the program.
Okay, and we have another question that came in asking, I've been told that there's a 30-day compliance period. Is that correct?
Normally, with a lot of our zoning enforcement, we give people, we tell them that they have 30 days because of the appeal rights before, to remove the signs. But like for instance, sometimes there's a 10-day appeal and sometimes there's 30-day appeal. So each notice of violation will specifically tell you the time frame for compliance.
Any other questions in the chat or any hands that are raised? Nothing?
No,
Okay.
that's all for now.
All right. Well, we'll go into our third and final segment of today, which is the signs part to the upcoming zoning ordinance amendment that we are kicking off. So, we as staff have identified some items that we'd like to consider as part of this amendment, but we really are interested in hearing what the community has, what different stakeholders have to say about some potential topics that we can consider. So first, like I mentioned during my presentation, we are looking at the comprehensive sign plan process. So this is something that currently goes to the Planning Commission and is for planned districts. So it's an avenue to request additional signage, for those, to create the placemaking components and to adapt to the creative planning process of the planned developments. So we are looking at potentially expanding the allowance of a comprehensive sign plan to commercial areas, maybe really just to areas that are not residential in nature. We have seen the desire for different shopping centers to come into the 21st century, not 20th century, and to have that creative placemaking to create that sense of identity for their shopping centers. So we do want to look at that process, as well as to include review standards and submission requirements in the zoning ordinance. So we do want to obviously allow for creativity and flexibility while giving us something to analyze and something to review as those comprehensive sign plans come in. We do also get a lot of questions about the calculations for different types of developments. Specifically, obviously, we're seeing a lot of mixed use development and multifamily buildings in Fairfax County, and there's some comments that we've received that the sign calculations aren't as clear as they could be, so we do want to look at that. And then there are a lot of other additional clarifications or updates that, were not made as the part one, the sign ordinance amendment part one, since that one really focused on the content neutrality. And this is now looking at the regulations and the processes. So just for example, we are looking at mobile parking, like, Target will have the little mobile parking pickup signs. What's the appropriate square footage for those types of signs? Any different types of roof mounted signs and different creative ways to have signage. And then also re-looking at those the properties that are for sale, for rent, for lease, and for the properties that are undergoing construction, just re-looking at those regulations and to see if those are appropriate for what we're seeing out there in Fairfax County. So this is really where, like I said, I want to hear from you all. I want to hear any thoughts on the current regulations. If there's a topic that needs to be revisited or hasn't been visited that should be, I'd really like to open it up to everybody and to get your thoughts on what we should be considering on with this amendment. So with that, are there any comments or any hands raised in the chat?
I'm not seeing any hands raised or any questions yet, but I feel
Okay.
like there should be.
We'll give a couple of minutes. I know that this is a lot of information to process, and obviously there are a lot of regulations involved in the Article 7 as well. And I'll talk just while, to see if people do have comments or questions in terms of general timelines. I am working on doing some outreach meetings in conjunction with DCC during this winter to spring this year. So we're looking to go out to a bunch of the land use groups, and we're getting those scheduled. The nonprofit leaders and faith-based leaders will be having an outreach meeting with them. And then we would like to go to the Board of Supervisors Land Use Policy Committee. We're targeting May to basically report out on this is what we're hearing from the community. These are the topics that we are thinking that they've been reoccurring as topics we should be considering, and to get the board's direction really in May. That once we have our marching orders and our scope really pinned down, then the rest of the year will be the drafting of the regulations and bringing the regulations out to the community for input on that. So that's kind of generally what we're looking at doing in terms of timeline. There's also a Supreme Court case going on in Austin, Texas, that has to do with billboards and digitization of signs. So we're keeping an eye on that to see when the timing is on when that decision will be rendered. That may have repercussions on different changes we need to make to our ordinance as well, depending on where they land. Still no comments or hands? Okay, well, we'll give a couple more minutes. Mike, did you have something to add?
Yeah, I just wanted to add something in regards to the signs in the right of way. Normally, when people received the informational warning letter, they do cease putting up their signs. However, some, habitually keep doing it, so we do have to invoice them. And once again, most of those, about 65% of the people pay. However, there are the ones that do not. So we have to forward those cases to the Office of County Attorney to recoup those fines. That works a really good part of the time. But then we also get the people that just continually put the signs out. They just write it out as a cost of doing business. However, we will forward those cases also to the Office of County Attorney to get an injunction to stop them from doing it, and eventually put, fines on them every time we see them. So hopefully that will, curtail that type of activity from those violators. But just wanted to make sure everybody's aware of that. Like I said, the key point is for the signs in the right-of-way program, it's only enforced Tuesday, Wednesday through Thursday. A lot of times people will put up signs Friday, keep them over the weekend, and they'll remove them on Monday. Like I said, people understand our program, and unfortunately we can't address it unless we see the sign, Tuesday through Thursday for signs in the right-of-way.
So Mike, I feel like you maybe, were just responding a bit to a question that did come in, and it was saying that for commercial businesses that are regularly posting in the right away, that there should be more of a penalty, that VDOT can take a while to respond and there can be some safety issues. So
like I said, we document, because normally how it works, the community labor force has their set schedule. Usually they hit every road probably 3 times in a month. So the day that they're going out, we will hit it the day before so we can document every sign. And so that way, when they go back out, they should have all the signs removed. So the next time we go out, we can see if there are any new signs, old signs, and stuff like that. But yeah, we understand, like, a lot of times it's a cat and mouse game, like I said, and people understand that we only go out Tuesday, Wednesday, and Thursday, type of thing. And we know that these signs do, it kind of litter the roadways. And sometimes if they do, block sight distances and stuff like that, we can address that by contacting VDOT to get those removed on a more quickly because of the life safety issue.
So I do want to add that I had a typo earlier in the presentation. The DCC number is 703-324-1300. So I will correct that for the PowerPoint that's posted. I accidentally listed the zoning administration number, but either way, we'll get you to the right people if you do contact one of the two. And yeah, Mike,
I saw it and I was like, I'm not saying anything. If they
like,
want to handle our complaints, I'm fine with that. They'll just forward them up to us.
Exactly. So I will correct that. I apologize for that typo. But if you do have questions or if you have thoughts on, the upcoming amendment, questions for me or for Mike, DCC in general, feel free to send us an email. I've got my email address and the phone number, as well as DCC's correct phone number on the slide here. So we're happy to, receive any information, any comments that you may have. I'm assuming there's still no hands or no more comments. Okay, all right. Well, you know where to find us. Again, I really appreciate you all taking your time, your lunch time to share with us today, and let us know if you have any other questions. All right. Thanks, everybody. Have a great day.